Good evening to all the participants as well as the students of the SLW 722. Welcome to my virtual class on 10th 5 2023. Yes, and read what I posted on the screen, participants. I said read what I posted on the screen so that you are with me and I'm with you. Both are traveling in the same vehicle to reach to the destination. Unmute and read. Rutambuka. I said unmute and read.
Welcome to the students of SLW 722 to my virtual class on the 10th May from 9:10 p.m. to 9:50 p.m. Effective functioning of human rights mechanisms, adaptation and strengthening of the United Nations machinery for human rights, rationalization of the work of the Commission, written statement submitted by the International Center for Human Rights and Democratic Development. Cause coordinator, Professor Dr. Mohammed Saheb Hussain.
Very good. So now, without wasting the time, we'll go to our next module, effective functioning of the human rights mechanism treaty bodies. And that we will see today now. It's Resolution 2002, Article 85 on effective implementation of the international instruments on the human rights, including the reporting obligation under the international instruments on human rights. The Commission on the Human Rights requested the Secretary General to report at its 60th session on the measure taken to implement the resolution and obstacles of its implementation and measures taken are planned to ensure financing and adequate staff and information for the effective implementation of the human rights treaty bodies. The present report is submitted pursuant to the request. So, development in the human rights treaty bodies, and since the adoption of the resolution 2002 Article 85, there has been a number of developments in the human rights treaty body system. The optional protocol to the conventions on the rights of the child, on the sale of children, child prostitution and child pornography, and on the involvement of the children in the armed conflict which entered into force on 18 January and 12th February 2002 respectively, attracted further notification and accession, further ratification and accession, and the Committee on the Right of the Child concerned the first report submitted in accordance with the optional protocol on the involvement of the children to armed conflict in its 34th session in September October 2003. The amendment to the Article 43 Paragraph 2 of the Conventions on the Rights of the Child, increasing the membership of the committee from 10 to 18 members, entered into force on 18th November 2002. On an enlarged committee met with the first time in the May 2003. So the optional protocol to the Convention against the torture and other cruel, inhumane or degrading treatment or punishment, establishing the system of the regular visits by the national bodies and subcommittee on the prevention of the Committee against the torture to visit the place of the detention was adopted by the General Assembly in the annex to Solution 57, Article 1999 of the 18th December 2002. In accordance with this Article 87, the International Conventions on the Right of the All Migrant Workers and members of their families entered into force on the 1st July 2003. And the first meeting of the Committee on the Protection of the Rights of the All Migrant Workers and Member of their Families is scheduled to take place from 1 to 5th March 2004. So, how the treaty bodies were responsible and making the effectiveness for the implementation of the international treaties in their domestic legislations. One is the CRC, it is made clear. Another is the torture, the Convention Against the Torture and Other Cruel, Inhuman, Degrading Treatment or Punishment. Then another is the International Convention on the Rights of the All Migrant Workers and the member of their families. Then it is their families, how they are scheduled and protected for the promotion of the human rights. These are the reports made based on the treaties. During the reporting period, the treaty bodies have continued to develop their working method. The Committee Against the Torture established a pre-accessional working group to facilitate in monitoring the activities. The Human Rights Committee or the Committee Against the Torture introduced the procedure to follow up their concluding observation in order to assist the implementation of the human rights treaties in state parties. These innovations, in particular, the follow-up procedures of the Human Rights Committee, have been successful with a high rate of the response from the parties to which the procedures has been applied. So, whatever the international instrument says and the treaty bodies, it is made it clear in where the Tanzania is a party, state party to those treaty parties, and they will see that it will be implemented in toto, and if there is any lacunae are there, that lacunae will be combated or filled with the changes in the domestic legislation, including the constitution. Informal meetings between the individual treaty bodies and the state parties to discuss working methods and other issues have been convened by all treaty bodies. Wherever there is a loophole, a gap would be there, then the treaty bodies as well as the state parties, they will convene a session and see that those gaps will be fulfilled. All chairpersons of the human rights treaty bodies were invited to address the 59th session of the Commission on the Human Rights, and 4 chairpersons were able to take advantage of this opportunity to brief the Commission on the work of their respective committees. So, these are the committees on the rights of the child, CRC, adopted a recommendation on its working methods in which it decided that for an initial period of the 2 years, it would consider the report of the states parties in 2 parallel chambers, each consisting of 9 members of the committee taking account of the equitable geographical representation. So they made the division of it and the equal representation depending upon the geographical division. The committee's recommendation was brought to the attention of the General Assembly. It's a 50th session, that is during the 30th session, which took place in the 12th to 13th January 2004. The Committee on the Elimination of the Discrimination Against the Women, that is a CEDAW, also discussed the option of the meeting in parallel working group of the consultation periodic report and the basis of the note submitted to the Secretariat. So, then all the treaty bodies plus the state parties, they will convene the meeting and the treaty bodies will suggest how the gaps could be covered. So, streamlining the reporting procedures, and treaty bodies have devoted significant attention to the idea of the Secretary General in Chapter 2, Section B of his report, strengthening the United Nations, an agenda for further change. So, in which they emphasize the importance of the continued efforts to modernize the human rights system. Again, the background for the growing delayed reporting or non-reporting by the states parties to human rights treaty bodies as well as the difficult demands reporting to the sixth committee imposes on state parties. So the state parties will make a report to the General Assembly from time to time when it is required. The Secretary General suggested that the committee craft a more coordinated approach to their activities, and B, that they standardize their varied reporting requirements. And he further suggested that each state be allowed to produce a single report summarizing its adherence of the full range of the international human rights treaties to which it is a party. And all the parties, they are supposed to submit the report as per the para 51. The report on the management review of the Office of the High Commissioner of the Human Rights conducted by the Office of the International Oversight Services during the 2002 recommended that the High Commissioner consistently pursue the consultation with the treaty bodies on the modalities of the consolidating reports on the various treaty bodies into a single national report with a view to achieving the steady progress towards its goal. Its resolutions, the General Assembly encouraged the state parties to the human rights treaties and the respective treaty bodies to review the reporting procedure for the treaty bodies with a view to developing a more coordinated approach and to streamlining the reporting requirement under this treaty. So, what I want to say is, how far the state parties implemented the treaty bodies where they are the member of the treaties, implemented in their domestic laws, and from time to time they have to submit the report to the General Assembly. And the General Assembly will monitor it by sending the expert committee depending upon the geographical region, and they will allot it to see that whatever the report is mentioned, it is in reality, it is in total, and it is a clear, and it is practically implemented, or it is only on the paper. So they will check it, cross-check it. Who? Treaty bodies committees. In all aspects, either the CRC, or the SIDA, or the torture, or the armed conflict, in many other fields they will touch it. So following the discussion with their respective committee, the chairperson of the treaty body provided a written response to the letter of the High Commissioner for the Human Rights, inviting the views on the Secretary General's proposals. Yes, whatever the Secretary General proposals are there, depending on the submission of this report to the General Secretary. A summary of these views is contained in the background document provided to a brainstorming meeting on the theme of the treaty body reform organized jointly by the OHCHR and the government of Liechtenstein and held in the Melbourne, Liechtenstein from the 4-7 May 2003. From the time to time, they will fix the place where this brainstorming session will be taken place. It was attended by the representative of all the treaty bodies, representative of the 5 state parties per the regional group, even the regional group members also, United Nations entities, national human rights institutions, and non-governmental organizations, and all the stakeholders will take part in the brainstorming session. So United Nations entities, national human rights institutions, and non-governmental organizations, the present background document in the report of the Melbourne workshop, of course it is held there, was considered by the second inter-committee meeting by the 15th meeting of the chairperson of the human rights treaty bodies convened in the Geneva. So from time to time they will make the places to convene such a meeting to make a brainstorming sessions. Both these meetings acknowledge the human rights treaty reporting system to be positive and successfully providing the creation of the constituency at the national level, which encourage the implementation of human rights at the country level. The innovations by the treaty bodies is follow up to their recommendations contained in concluding observations or comments were welcomed, and the strengthening of the rule of international human rights institutions in the reporting system and its follow-up was encouraged. So now, if you say the gist of what we now just discussed, based on the report of the state parties to the General Assembly, the General Assembly will go through the report from the state parties and see that the state parties, those who are the member treaties, and whatever the treaties they signed it, whether it is implemented in a proper way or not, in their different organizational setup to make the enforcement and efficient functioning of the human rights in the protection and promotion of it. So there comes all the stakeholders, UN treaty body committees, state representatives, regional body representatives, and they will sit together and make the brainstorming session in different places. And whatever the brainstorming session outcomes, and those outcomes should be suggested to the state parties to implement their domestic legislations. So you cannot remember the places, you cannot remember the resolutions, dates, but overall the gist is you have to mention what they recommended, what they suggested, and such a suggestion should be incorporated in their domestic legislation where they find any gap. So that is the whole gist which I just now made. I don't know how far that you understood. Sir, somehow we understood. What is meant by somehow? 10%, 15%, 20%, or 0%? Participants, I'm asking you.
80%.
Sauti kubwa. Ongeza sauti.
80%. 80%.
Mashallah, mashallah. Only Rutumbuka 80%. What about my James Masave?
I guess the same, sir.
So
80%.
that means whenever a judgment is given by the Chief Justice or the Prime Judge, the other judges, they will write, I conquered with my learned friend, and sign it. If any dissenting judgment is there, they have to elaborate it by keeping the face value. See, these are all the things what we want to make it out. How far effectiveness would be there in doing so? For effectiveness of doing so, I told you the agencies which are established in the Tanzania, they have to take care of in each aspect of it. Because different agencies are formed and they will function in different areas on the different topics. And that to be based on the treaties where the state Tanzania is signed and ratified, party to those treaties. That is the overall what I want to say. The second intercommittee meeting also made recommendation endorsed by the meeting of the chairperson concerning the consistency in the examination of the state parties, reports by the treaty bodies, cross-referencing the concluding observations and comments, collaborations on general comments and recommendations, the role of national human rights institutions, capacity building, follow-up to the concluding observation, and the encouragement of the timely reporting. So, the cross-cutting edges and the capacity building, reinforcing, and the cross-referencing and observation made by the different stakeholders, including the treaty bodies, brainstorming, suggestions made by them, and all those will be followed to the concluding observation and the encouragement of the timely reporting, and these should be incorporated in their gaps where they fail to do so. Then only the effectiveness of these protection and the promotion of the human rights in the Union Republic of Tanzania will be made together or pointed out or fulfilled. The meeting of the chairperson noted that intercommittee meetings provided a valuable forms of discussion and the opportunity to develop the consistent and coherent approach by the treaty bodies to substantiate human rights issues, and recommended that it will be convened annually immediately prior to the annual meeting of the chairperson, and the two meetings should take place during the same 1 week period. In general, they will sit once in a year. If the necessity comes, they sit twice also to see that how far they could effectively implement those human rights in a different aspect of it, where the state parties are subject to the treaties. So in accordance with the request made by the second intercommittee meeting, the 15th meeting of the chairperson draft guidelines of an expanded core document harmonized the guidelines for reporting all treaty bodies are being prepared by the Secretariat. So the treaty bodies are being briefed on these preparation in the course of the first half of 2004. So in order to assist the ensuring consistent approach against the treaty bodies, the treaties and the commission, the branch of the OHCHR, which provides a technical and substantive servicing to the 6 Geneva-based committees, and introduce a pooling system where all the staff of all the committee secretariats are available to support each of the treaty bodies. So the treaty bodies' suggestions, the recommendations, and the report made by the state parties, and the observation made by the Secretary General, the brainstorming session outcome, and all that outcome just should be implemented, and it is domesticated in their respective legislation, including the Constitution, where it is necessary to amend it. Yes, it should be amended. So technical assistance provided to state parties. So initial reports of the states parties required under the various treaties were overdue, in which 114 had been overdue for more than 5 years. So how many treaties would be there? How many overdues would be there in the 5 years? So that would be taken up. Furthermore, a total of the 660 periodic report from the state parties were overdue. See, there are many overdue plans are there, reports are there. Yes, those should be fulfilled, and it should be submitted to the General Assembly or Secretariat, General Secretariat. So treaty bodies encourage the state parties with overdue reports to avail themselves of the technical cooperation programs provided by the United Nations assist in reporting. If they want, they can take the assistance of the technical bodies, the UNO technical reporting, they can take the assist it and see that the due should be cleared in preparation of the reports. With the exception of the CEDAW, treaty bodies have adopted the practice of reviewing the implementation in the state parties whose reports are significantly overdue in the absence of a report. So if any overdue reports are there, again they will sit together and they will review it. In case of the necessity, they will take the assistance of the UN skilled technical staff in preparation of the reports. So the technical cooperation program of the United Nations in the field of the human rights provide a support. Yes, United Nations technical support would be given to the state parties at the request of the states to efforts to meet the reporting obligation through the regional or sub-regional and national training workshops on reporting on their treaties. So even they can sit together and make the brainstorming session, and they will run the workshops either national level or regional level or the state level or the district level also. The United Nations fellowship programs in the field of human rights has traditionally been dedicated to reporting under the treaties. So the report of the Secretary General to the Commission on the advisory services with technical cooperation in the field of the human rights, yes, the state parties application should be made to the UN for the technical support for clearing the overdue reports. So during the reporting period, OHCHR has organized two activities on the implementation of the concluding observation on the human treaty bodies. And then the government of Ecuador and the OHCHR organized a pilot workshop for the dialogue on concluding the observation of the Committee on Human Rights in Quito. And from time to time, in the 2003, that OHCHR organized a workshop on the implementation of the concluding observation of the Committee on the Right of the Child, Damascus, Syria, Arab republics. Yes, in the regional also they will sit together and they will try to make the report from the different regionals also. Participants in both the activities, including the representative of the government and the non-governmental institutions, national human rights institutions, and the entities of the United Systems, treaty bodies, and the special agencies, they will sit together and they will try to make the report and see that report should not have any loopholes. So individual compliance procedure, if any under that optional obligations for the treaty, an individual can also write a report to the UNO or the regional bodies. So in establishment of the year 2000, dedicated the petition team to lead the individual communications submitted in the optional protocol. I told you, optional protocol to the international covenants on the civil and political rights. Even an individual can approach them and write the report. And the convention on the elimination of all forms of the racial discrimination. These are the two treaties which is having the effective force. It is having the teeth to implement. Otherwise, UN make a sanction also if anybody violates it. The Committee Against the Torture, to be headed and approved by the program budget, has resulted in the significant reduction in the delay of the proceeding individual compliance. So under the optional protocol for the international conventions, yes, an individual can also write a report. The average time taken to review the complaint has been reduced during the reporting period of 8 months. Of course, the period should be reduced over there and there should not be any undue delay in addressing the issues and challenges were raised by the individuals under the optional protocols. So, the petition team prepared the draft of decision and recommendation with approximately 150 individual complaints. See, one not two, not 150 individual complaints. per year for the consideration of the treaty bodies. And of these, 115 have been considered by the Human Rights Committee as compared to the 78 cases were dealt with during the previous 2 years. And some of the may be frivolous also. And the frivolous complaints of the individual can be overlooked. But the substantive things where it is happened over there, that would be just addressed. The Human Rights Committee convened an additional 1 week of the meeting during the 78th session in order to reduce the backlog in the consideration of the pending registered individual complaints. If the individual complaints were not addressed properly, yes, the time extension could be there for those complaints which is having the substantial evidence, not the frivolous complaints. So the delay in dealing with the correspondence relating to the individual complaints have been significantly reduced, with the only remaining backlog relating to the complaint received in Russia, and although the backlog is far less during the period, and from each country the individual complaint will go, but a speedier processing of the correspondence has been encouraged, and a submission of the more individual complaints, in particular those directed in the Human Rights Committee. So in respect to which the number of their cases registered was risen, of course, individual complaints should also be entertained by the UN treaty bodies and the state regional agencies or bodies, those who are working for the protection and the promotion of the human rights in the United Republic of Tanzania or any state, they have to do the same. So the determination of the work of human rights treaty bodies, how it can be made. So efforts to develop the harmonize the various electronic database concerning the human rights treaty bodies have continued, as have those to strengthen the pages of the websites, the OHCHR and the Division of the Advancement of the Women relating their work. A list of these allowing for the automatic dissemination of the and concluding the comments, recommendations and the decisions of the treaty bodies on individual communication has been established by the office. The office also exploring the possibility of the developing information technology tools to assist in reporting, both with regard to the compilation of the production of the reports by the state parties and the processing reports of the treaty bodies. So a sophisticated technology can be used over there to expedite for the individual complaint addressing and the reports by the treaty bodies, and these reports should be submitted time to time to the General Assembly and Secretary General also. So in each aspect of it, the effective implementation would be needed. And I told you also, there are beautiful cross-cutting edges, capacity building, comprehensive things, and strengthening the human rights and curbing the activities of the perpetrators. Beautifully, it is decorated in the reports. But when the matter comes to the enforcement is concerned, their machinery would be fail because of no effective implementation, number one. Number two, the people, those who are working for that regard, they should also be given their subsistence. And that means allocation of the budget in conducting the seminars, in conducting the workshops and making the reports and preparing the reports in a clear-cut manner to understand it and to submit it, both the soft copies as well as the hard copies, by making the graphic representation also. That means IC technological skills will be needed in streamlining the report and expediting the report either for the submission of the individual reports addressing or the reports submission to the treaty bodies are concerned. So these are the things which I would like to highlight it today regarding the effectiveness, how treaty bodies should be there and the regional agencies or bodies, those who are try to protect and promote the human rights in different sectors should have to work together with the stakeholders, treaty bodies, UN experts and state parties, including the NGOs, and taking the advice and recommendation of the a good Samaritans, including the universities and the practicing people, and taking the advantage of and the opinion of and the suggestion of the foreign people, those who are experts in that field. So these are the things which I would like to say in the effectiveness is concerned. Yes, and if you see it in the course outline again, a different effectiveness in the different sectors are there. For instance, if you say that how the effectiveness would be there in each 5 organs, including the ICJ, how far the protection would be there in each organs and each agencies, each special organs, they will may ask either by the special agency effectiveness or the treaty body effectiveness or the effectiveness of the ICJ or effectiveness of the secretary, that council for the socio-economic things and how they can take care of it, including the WHO also. How far the effectiveness would be there in the protection of the health of the subject where the state is a party to the WHO. In addition to that, in the working conditions and where the Tanzania also party for the ILO and the effectiveness of the working condition of the workers under the ILO. And there also they will check it how far the human rights protection and promotion would be there in that area. So they may ask a common question or they may ask the individualized regarding the organs are concerned, agencies are concerned, and even Human Rights Commission is concerned, Human Rights Council is concerned, they may ask separately also how far the effectiveness would be there. Even they can ask the effectiveness in the regional centers in the promotion and protection of the human rights. Participants, are you there?
Yes, Prof.
We are here, sir.
So in the course outline, when you see it now in different area also, we can make it out how the effectiveness would be there. So here they say merely the effectiveness of the United Nations human rights system. In the human rights system, all 6 organs will come. So each organ we have to make it out how the effectiveness in the particular area. So today we dealt only the human rights treaties. Is it clear?
Yes.
Effectiveness of the United Nations in the human rights system. Today we consulted only the human rights treaties. Those are the things we covered here. See, I have shown you already in the beginning. Yes. Read the heading. Read the heading.
Economic and Social Council.
Yes. And read effective functioning of the
Human rights mechanisms, treaty bodies.
Yes, we discussed today treaty bodies. And we will see next class effectiveness in the different body, different agency, different organ. So you have to make the gist how far each organ, each agency, how far it is effectiveness should be there. and you have to see, because these are all organs come under the United Nations system. In system, these are the agencies, these are the special bodies, these are the member states, and these how they can implement it in the protection and promotion of the human rights in the different level. Like I told you, no armed conflict, women's torture, child's protection, and pornography, child sexual abuse, and migrant workers, and different fields, it will be touched. So with this, I would like to stop today's lecture. If you have any doubt, you can get the clarification from me. Yes, anything should be asked.
Yes, Prof.
Ask.
Instance here in Tanzania,
Yeah.
the effectiveness of the government institutions
Mm-hmm.
in promoting the protecting the promotion of human rights.
Mm-hmm.
Which organs are in fact involved in here in Tanzania?
You know, maybe no, SEDA is there, no? We discussed 4 or 5 organs. You hear that in my earlier class, we discussed in
Yes.
Tanzania in the first, where we are discussing in the Tanzania perspective, there are 5 organs are there.
Which are
Like SEDA is
Drug.
there, and CRC is
SEDA?
there, yeah, and OCHRAG is there, CHRAGG Chirag is there. We discussed it.
Yes, yes, I was trying to think about the judiciary.
No, judiciary, no, the point is, if a person file a case regarding the human rights, at that instance, judiciary will interfere. Otherwise, judiciary will not interfere in any matter. But some cases, suo motu, the High Court can give a notice to the Superintendent of Police or a regional body who is an officer over there to submit the report of any human right violations are occurred over there. For instance, if any mass gang rape is there of a agriculture workers in particular area, at that instance, if it is noticed by any individual or the organization or the NGOs or the media, at that instance, yes, they can issue a notice to a particular officer who is in charge of the law and order in particular area to submit the report. At that instance, they have to follow it, what happened actually, and the report. And if the report is in proper way or not, even a commission would be appointed to see and get direct to face interview from the victims. Again, that commissioner report also will be taken into consideration, and both the reports they will check it, and if any discrepancy is there, they call for the explanation. But otherwise, no. And the High Court is having a jurisdiction in such a matter, and the High Court suppose fails to do or any party aggrieved, then they can go to the Court of Appeal, and if any party will be agreed over there, then the people's right is there in Arusha, they will approach over there. Once it is decision is given by that, if they want, they can apply for the review, or it is a final. If the substantial question comes over there, then it may go to depending upon the nature of the offense to the ICJ if the human rights violations are too much over there. So that is the mechanism that we will apply it in the human rights protection and promotion. And then a case would be filed by the organization also, like NOLA is there. You know NOLA?
Yes, Nora.
NOLA has filed several human rights cases. And that's the way that it can be handled and taken care of it. The point again is no, for its implementation, budget allocation is very much important factor. If the budget will not be there, the people will not go and work over there and get the interviews report direct to face. They will ask them, and for them the subsistence will be given, and they would work it and they will make it out that the expenditure involved over them in the printing and compiling and using, yes, these are all the things should be borne by it. Then only it can be undertaken. Otherwise, if the budget will not be there, they will sit in the office and prepare the report. Are you following me?
Yes, Prof.
Without going to the spot area where the violations have occurred. So this is the way that we can tackle it and we can make it out. And tomorrow we'll see again in different field how the effectiveness should be there. So with this, I would like to stop my today's online class and see you tomorrow. Usiku mwema, indoto njema, and koheri.
Asante na kwako pia, Prof.
Ndio.
working on social media for my clients. I create a lot of video content